Question 1. Regulatory review indicates that a resident of Nebraska holding a valid Nebraska concealed handgun permit plans to travel to South Dakota and intends to carry a concealed pistol. What is the most appropriate course of action for this individual to ensure compliance with South Dakota law regarding the carrying of concealed pistols by non-residents? Option A. Rely solely on the laws and regulations of Nebraska, as their permit is valid in their home state, and assume these provisions extend to South Dakota. Option B. Assume that the Nebraska concealed handgun permit is automatically recognized and valid for concealed carry throughout South Dakota due to reciprocity. Option C. Apply for a South Dakota non-resident permit to carry a concealed pistol, ensuring all eligibility requirements are met according to South Dakota codified law. Option D. Carry the concealed pistol in South Dakota only in locations where carrying is permitted under Nebraska law, without obtaining a South Dakota permit. Correct answer is C. Apply for a South Dakota non-resident permit to carry a concealed pistol, ensuring all eligibility requirements are met according to South Dakota codified law. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of South Dakota's concealed carry permit regulations for non-residents, specifically concerning reciprocity and the potential for misinterpreting the scope of a permit issued by another state. Careful judgment is required to ensure compliance with South Dakota law, which prioritizes its own statutory requirements for carrying a concealed pistol, even for individuals holding permits from other jurisdictions. The best professional approach involves verifying the specific requirements for a South Dakota non-resident permit to carry a concealed pistol, even if the individual possesses a valid permit from their home state. This is correct because South Dakota Codified Law, SDCL, Chapter 23-7, specifically SDCL 23-7-53, outlines the conditions under which a non-resident may be issued a permit. While South Dakota has reciprocity agreements with many states, these agreements do not automatically grant the same rights and privileges as a South Dakota permit. A non-resident must still meet South Dakota's eligibility criteria and apply for a permit if they intend to carry a concealed pistol within the state, especially if their home state permit does not align with South Dakota's specific provisions. This ensures full legal compliance and avoids potential legal entanglements. An incorrect approach would be to assume that a valid concealed carry permit from another state automatically allows for concealed carry in South Dakota without further inquiry. This fails to acknowledge that reciprocity is not universal and that South Dakota law governs the act of carrying a concealed pistol within its borders. Relying solely on a permit from another state without confirming its validity and recognition under South Dakota law could lead to a violation of SDCL 23-7-53, which mandates that a non-resident must obtain a South Dakota permit to carry a concealed pistol if they do not meet the specific criteria for recognition of their home state permit. Another incorrect approach would be to only consider the laws of the individual's home state when carrying in South Dakota. This is a critical error as the jurisdiction where the act of carrying occurs is paramount. South Dakota law, as outlined in SDCL Chapter 23-7, dictates the rules for carrying concealed weapons within its territory, regardless of where the permit was issued. A further incorrect approach would be to believe that if the home state permit allows for carrying in certain locations, those same allowances automatically apply in South Dakota. This overlooks the fact that South Dakota has its own specific restrictions on where concealed pistols can be carried, as detailed in SDCL 23-7-54, which may differ significantly from the restrictions in the individual's home state. The professional decision-making process for similar situations should begin with identifying the jurisdiction in which the activity will take place. Next, one must thoroughly research the specific laws and regulations of that jurisdiction pertaining to the activity in question. This includes understanding any requirements for permits, licenses, or registrations, as well as any reciprocity agreements or specific provisions for non-residents. If there is any ambiguity, or if the individual holds a permit or license from another jurisdiction, it is imperative to confirm its validity and recognition under the laws of the target jurisdiction. When in doubt, seeking clarification from the relevant authorities or legal counsel is the most prudent course of action to ensure full compliance and avoid legal repercussions. Question 2. Performance analysis shows that a South Dakota resident is processing an application for a non-resident permit to carry a concealed pistol from an individual who resides in a neighboring state. The applicant has provided a valid concealed pistol permit issued by their home state. What is the most appropriate course of action for the South Dakota permit issuer to ensure compliance with South Dakota codified law? Option A. Accept the applicant's assertion that they meet all requirements and process the permit without independently verifying their home state permit status or South Dakota's recognition of it. Option B. Deny the application solely on the basis that the applicant is not a resident of South Dakota without investigating reciprocity or specific non-resident provisions. Option C. Issue the non-resident permit immediately, as the possession of a valid permit from the applicant's home state is sufficient proof of eligibility. Option D. Verify the validity of the applicant's home state permit and confirm that South Dakota recognizes such permits, while also ensuring the applicant meets all South Dakota eligibility requirements for permit holders. The correct answer is D. Verify the validity of the applicant's home state permit and confirm that South Dakota recognizes such permits, while also ensuring the applicant meets all South Dakota eligibility requirements for permit holders. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of South Dakota's specific requirements for non-resident concealed pistol permits, particularly concerning reciprocity and the applicant's home state's laws. Misinterpreting these requirements can lead to the denial of a legitimate application or, worse, the issuance of a permit to an individual who does not meet all legal criteria, potentially compromising public safety. Careful judgment is required to ensure adherence to South Dakota Codified Law, SDCL, Chapter 23-7, specifically regarding the recognition of permits from other states and the qualifications for a non-resident permit. Correct approach analysis. The best professional practice involves a thorough review of the applicant's documentation to confirm their home state's permit is valid and recognized by South Dakota, and that the applicant meets all South Dakota eligibility criteria for a non-resident permit. This approach aligns with SDCL 23-7-10, which outlines the conditions under which South Dakota recognizes permits issued by other states, and SDCL 23-7-7, which details the requirements for obtaining a permit, including the need for the applicant to be a resident of South Dakota or to meet specific non-resident criteria. Verifying the applicant's home state's permit status and ensuring they meet South Dakota's age and background check requirements are paramount. Incorrect approaches analysis. One incorrect approach involves assuming that because the applicant possesses a valid concealed pistol permit from their home state, it automatically qualifies them for a South Dakota non-resident permit without further verification. This fails to acknowledge that South Dakota may have different eligibility standards, or that reciprocity agreements might have specific limitations not met by the applicant's home state permit. This overlooks the explicit requirements for non-residents under SDCL 23-7. Another incorrect approach is to process the application solely based on the applicant's assertion of meeting all requirements, without independently verifying the validity and recognition status of their home state permit. This bypasses the due diligence mandated by SDCL 23-7-10 and the background check requirements inherent in SDCL 23-7-7, potentially allowing an unqualified individual to obtain a permit. A third incorrect approach is to deny the application solely because the applicant is not a resident of South Dakota, without considering the specific provisions for non-resident permits, as SDCL 23-7-7 explicitly allows for non-residents to obtain permits under certain conditions, and a blanket denial based on residency alone is a misapplication of the law. Professional reasoning. Professionals should adopt a systematic approach to permit applications. This involves 1. Identifying the applicant's residency status. 2. If a non-resident, determining if South Dakota has a reciprocity agreement with the applicant's home state for concealed pistol permits, as per SDCL 23-7-10. 3. Verifying the validity and current status of the applicant's home state permit. 4. Ensuring the applicant meets all South Dakota eligibility criteria for permit holders, including age and background checks, as outlined in SDCL 23-7-7. 5. Documenting all verification steps and decisions. Question 3. Quality control measures reveal that an applicant for a South Dakota non-resident permit to carry a concealed pistol has provided documentation that includes a slight discrepancy in their stated residential address, listing a temporary mailing address rather than their permanent out-of-state domicile. The applicant claims this was an oversight, and they intend to spend significant time in South Dakota. Which of the following approaches best addresses this situation in compliance with South Dakota law? Option A. The applicant should withdraw their application and reapply later once they have established a more permanent residence in South Dakota, even though they are applying for a non-resident permit. Option B. The applicant should proceed with the application as is, assuming the discrepancy is minor and will be overlooked given their stated intention to spend time in South Dakota. Option C. The applicant should contact the South Dakota Sheriff's Association to inquire if a temporary mailing address is acceptable for non-resident permit applications without formal amendment. Option D. The applicant should immediately amend their application to accurately reflect their permanent out-of-state domicile and any relevant temporary South Dakota address, ensuring all information aligns with South Dakota Codified Law Chapter 23-7 regarding permit eligibility and application accuracy. The correct answer is D. The applicant should immediately amend their application to accurately reflect their permanent out-of-state domicile and any relevant temporary South Dakota address, ensuring all information aligns with South Dakota Codified Law Chapter 23-7 regarding permit eligibility and application accuracy. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements for obtaining a South Dakota non-resident permit to carry a concealed pistol while also adhering to the ethical obligations of providing truthful and complete information. Misrepresenting information, even if seemingly minor, can have serious consequences for the applicant's ability to obtain the permit and their future firearm rights. The challenge lies in ensuring absolute accuracy and transparency in the application process. Correct approach analysis. The best professional approach involves the applicant diligently reviewing all provided documentation, cross-referencing it with their personal history, and ensuring every piece of information submitted is accurate and complete. This includes verifying the accuracy of their address, any prior convictions or disqualifying events, and confirming they meet all eligibility criteria as outlined in South Dakota Codified Law Chapter 23-7. Specifically, SDCL 23-7-5 outlines the requirements for a permit, including the applicant's eligibility and the prohibition of providing false information. By taking this meticulous approach, the applicant demonstrates good faith and adherence to the legal framework governing concealed carry permits in South Dakota. Incorrect approaches analysis. Submitting an application with a known discrepancy in their residential address, even if they intend to reside in South Dakota for an extended period, is a regulatory failure. South Dakota law requires accurate residency information for non-resident permits, and misrepresentation can lead to denial or revocation. Similarly, failing to disclose a past misdemeanor conviction that might be relevant to firearm eligibility, even if the applicant believes it is minor or expunged, constitutes a failure to provide complete information as required by SDCL 23-7-5. This omission can be interpreted as an attempt to conceal disqualifying information. Finally, assuming that a permit from another state automatically fulfills all South Dakota requirements without verifying specific reciprocity or additional application steps is a misunderstanding of the non-resident permit process and a failure to comply with South Dakota's specific application procedures. Professional reasoning. Professionals assisting applicants in this process should emphasize the importance of honesty and thoroughness. They should guide applicants to carefully read and understand all application instructions and relevant state statutes. A systematic review of personal history against the statutory requirements is crucial. If any doubt exists about the completeness or accuracy of information, it is always best to err on the side of full disclosure and seek clarification from the issuing authority rather than risk misrepresentation. Question 4. The monitoring system demonstrates that a significant number of South Dakota non-resident permit to carry concealed pistol holders have permits that are due to expire within the next 90 days. What is the most responsible and legally compliant course of action to ensure these individuals maintain their permit status? Option A. Proactively generate and send personalized renewal reminders to each permit holder whose permit is expiring within 90 days, including clear instructions on the renewal process and relevant deadlines. Option B. Wait for permit holders to contact the relevant authorities to inquire about renewal procedures once their permits have already expired. Option C. Rely exclusively on any official renewal notification system provided by the state of South Dakota, without implementing any internal tracking or supplementary communication. Option D. Assume that permit holders are fully aware of their permit expiration dates and will initiate the renewal process independently, without any prompting. The correct answer is A. Proactively generate and send personalized renewal reminders to each permit holder whose permit is expiring within 90 days, including clear instructions on the renewal process and relevant deadlines. Explanation: the monitoring system demonstrates a potential lapse in diligence regarding the renewal process for a South Dakota non-resident permit to carry a concealed pistol. This scenario is professionally challenging because it requires a proactive understanding of regulatory timelines and the consequences of non-compliance, even when the primary responsibility for renewal technically rests with the permit holder. A failure to act could have significant legal ramifications for the individual and potentially reflect poorly on the entity responsible for facilitating such permits, even if indirectly. Careful judgment is required to balance administrative efficiency with the absolute necessity of regulatory adherence. The best approach involves proactively identifying and notifying permit holders whose South Dakota non-resident permit to carry a concealed pistol is approaching its expiration date. This proactive notification, ideally sent well in advance of the expiration, ensures the permit holder is aware of their responsibility to renew and provides them with sufficient time to complete the necessary steps. This aligns with the spirit of South Dakota law, which, while placing the onus of renewal on the individual, implicitly encourages responsible gun ownership through a structured permitting process. By facilitating timely renewal, the entity upholds the integrity of the permitting system and helps prevent unintentional violations of concealed carry laws. An incorrect approach involves assuming the permit holder will independently manage their renewal without any reminder. This fails to acknowledge the potential for oversight or forgetfulness on the part of the permit holder, leading to an expired permit. Such an approach risks the permit holder unknowingly carrying a concealed pistol without a valid permit, which is a violation of South Dakota law and can result in severe penalties. Another incorrect approach is to only provide renewal information upon direct request from the permit holder. This reactive stance is insufficient, as it places the entire burden of remembering and initiating the renewal process on the individual, increasing the likelihood of missed deadlines. It does not reflect a commitment to assisting permit holders in maintaining compliance with South Dakota's concealed carry regulations. A further incorrect approach is to rely solely on the state's notification system, if one exists, without implementing an independent internal tracking mechanism. While state notifications are important, they may not always be received or may arrive too late. A robust internal process that complements state procedures is essential for ensuring comprehensive compliance and preventing accidental lapses. The professional reasoning process for similar situations should involve establishing clear internal protocols for tracking permit expiration dates. This includes setting up a system to flag permits nearing expiration and initiating timely, proactive communication with the permit holder. The focus should always be on facilitating compliance with South Dakota's concealed carry laws and preventing situations where an individual might unknowingly violate them due to administrative oversight. Question 5. The audit findings indicate that a South Dakota Sheriff's Office processed a non-resident permit to carry a concealed pistol application for an individual whose home state's concealed carry laws were not formally assessed for substantial similarity to South Dakota's requirements, relying instead on the applicant's possession of a valid permit from that state. Considering South Dakota Codified Law Chapter 23-7, which of the following actions represents the most appropriate and legally compliant response to this situation? Option A. Request the applicant to provide a sworn affidavit confirming their home state's permit is equivalent to South Dakota's standards. Option B. Immediately initiate a formal review to determine if the applicant's home state's concealed carry permit requirements are substantially similar to those of South Dakota, and if not, revoke the permit and notify the applicant, Option C. Issue a warning to the sheriff's office for procedural oversight, but allow the permit to remain valid as the applicant possessed a permit from their home state. Option D. Conduct a background check on the applicant within South Dakota to ensure they meet state eligibility criteria without further investigating their home state's laws. The correct answer is B. Immediately initiate a formal review to determine if the applicant's home state's concealed carry permit requirements are substantially similar to those of South Dakota, and if not, revoke the permit and notify the applicant. Explanation. The audit findings indicate a potential lapse in diligence regarding the verification of an applicant's eligibility for a South Dakota non-resident permit to carry a concealed pistol. This scenario is professionally challenging because it requires a thorough understanding of South Dakota's specific statutory requirements for non-resident permits, balancing the need for efficient processing with the absolute necessity of upholding public safety and legal compliance. A failure to adhere strictly to these requirements could have significant legal ramifications for the issuing authority and compromise the integrity of the permitting process. The best approach involves a meticulous review of all submitted documentation against the explicit criteria outlined in South Dakota Codified Law, SDCL, Chapter 23-7, specifically focusing on the provisions related to non-resident applicants. This includes verifying that the applicant possesses a valid concealed carry permit from their home state, that their home state's permit requirements are substantially similar to South Dakota's, and that the applicant meets all other eligibility criteria such as age and residency status in their home state. This approach is correct because it directly aligns with the statutory mandate to ensure that only individuals who meet South Dakota's safety and legal standards are issued permits, thereby upholding the law and protecting public safety. An incorrect approach would be to assume that a valid permit from another state automatically satisfies South Dakota's requirements without further scrutiny. This fails to acknowledge SDCL 23-7-53, which mandates that South Dakota shall issue a permit to a non-resident if the applicant possesses a permit from their home state and that state's requirements are substantially similar to South Dakota's. Simply accepting the out-of-state permit at face value bypasses this critical comparative analysis. Another incorrect approach would be to grant the permit based on a cursory review of the application, overlooking discrepancies or missing information related to the applicant's home state permit or their eligibility under South Dakota law. This demonstrates a lack of due diligence and a failure to adhere to the procedural safeguards established by SDCL 23-7. A further incorrect approach would be to rely on informal assurances or verbal confirmations from the applicant or their home state agency regarding the validity and equivalency of their permit, without obtaining and reviewing the necessary official documentation. This bypasses the established legal framework for verification and introduces an unacceptable level of risk. Professionals should employ a decision-making framework that prioritizes strict adherence to statutory requirements. This involves developing clear checklists and verification protocols for non-resident applications, ensuring that all required documentation is obtained and thoroughly reviewed against the specific provisions of SDCL Chapter 23-7. Regular training on these requirements and periodic audits of the permitting process are essential to maintain compliance and uphold public trust. Question 6. The audit findings indicate that a South Dakota Sheriff's Department has been issuing non-resident permits to carry a concealed pistol based primarily on the applicant's possession of a valid permit from their home state, with minimal independent verification of South Dakota's specific eligibility criteria. Considering the provisions of South Dakota Codified Law Chapter 23-7, which of the following actions represents the most appropriate and legally compliant procedure for processing a non-resident concealed pistol permit application? Option A. Rely solely on a national criminal background check to determine eligibility, without independently verifying the applicant's firearms training or their home state's specific permit requirements. Option B. Issue the non-resident permit automatically if the applicant provides proof of a valid concealed carry permit issued by their state of residence, assuming reciprocity covers all necessary qualifications. Option C. Deny the non-resident permit application if the applicant has any prior minor offenses on their record, even if those offenses are not specifically listed as disqualifying under South Dakota law for permit issuance. Option D. Conduct a thorough review of the applicant's submitted documentation to ensure they meet all South Dakota statutory requirements for non-resident permit holders, including verification of their home state residency, absence of disqualifying factors under state and federal law, and completion of approved firearms training before issuing the permit. The correct answer is D. Conduct a thorough review of the applicant's submitted documentation to ensure they meet all South Dakota statutory requirements for non-resident permit holders, including verification of their home state residency, absence of disqualifying factors under state and federal law, and completion of approved firearms training before issuing the permit. Explanation: the audit findings indicate a potential lapse in due diligence regarding the verification of a South Dakota non-resident applicant's eligibility for a concealed pistol permit. This scenario is professionally challenging because it requires a thorough understanding of South Dakota's specific statutory requirements for non-resident permits, balancing the applicant's rights with public safety obligations, and adhering to the principle of reasonable cause for denial. A failure to properly assess eligibility could lead to the issuance of a permit to an individual who does not meet the legal criteria, potentially compromising public safety and exposing the issuing authority to legal repercussions. The best approach involves a meticulous review of all submitted documentation against the explicit criteria outlined in South Dakota Codified Law, SDCL, Chapter 23-7, specifically focusing on the provisions related to non-resident applicants. This includes verifying the applicant's residency in their home state, confirming they are not disqualified under any state or federal law, such as being a convicted felon, subject to a domestic violence restraining order, or having a documented history of mental instability, and ensuring their training meets South Dakota's standards. The justification for this approach lies in SDCL 23-7-50, which mandates that the sheriff shall issue a permit if the applicant meets the qualifications and is not disqualified. The law requires a proactive assessment of eligibility, not a passive acceptance of submitted information. An incorrect approach would be to assume that because an applicant has a permit from their home state, it automatically qualifies them for a South Dakota non-resident permit. This fails to acknowledge that South Dakota has its own specific requirements for non-residents, which may differ from other states, and that SDCL 23-7-50 requires an independent assessment by the South Dakota Sheriff. Another incorrect approach is to deny the permit solely based on a vague suspicion or unsubstantiated rumor without concrete evidence that violates the disqualifying criteria outlined in SDCL 23-7-51. This would violate the applicant's due process rights and the statutory requirement for specific grounds for denial. Finally, relying solely on a background check without reviewing the applicant's training documentation would be insufficient, as SDCL 23-7-52 specifies the required training for permit applicants, including non-residents. Professionals should employ a systematic decision-making process that prioritizes adherence to statutory mandates. This involves 1. Clearly identifying all applicable legal requirements for the specific permit type, non-resident concealed pistol permit in South Dakota. 2. Meticulously reviewing all submitted documentation against each requirement. 3. Seeking clarification or additional documentation when information is incomplete or ambiguous. And 4. Making a determination based solely on the established legal criteria and evidence, ensuring fairness and compliance with the law. Question 7. The assessment process reveals that an applicant for a South Dakota non-resident permit to carry a concealed pistol has a prior misdemeanor conviction for simple assault. The applicant believes this conviction is minor and should not affect their eligibility. Based on the South Dakota codified laws, what is the most appropriate professional course of action when advising this applicant? Option A. Advise the applicant that eligibility is determined by a strict review of South Dakota codified laws, specifically SDCL 23-7-50, and that a simple assault misdemeanor may be a disqualifying offense depending on its classification and the specific statutory language, recommending they consult the official statutes or the Attorney General's office for definitive guidance. Option B. Recommend that the applicant simply proceed with the application and that the authorities will likely overlook a misdemeanor conviction of this nature. Option C. Assure the applicant that simple assault is a minor offense and generally not considered a disqualifying crime for concealed carry permits in South Dakota, regardless of the specific statutory provisions. Option D. Inform the applicant that since their conviction was a misdemeanor and not a felony, it will not disqualify them from obtaining a South Dakota non-resident permit to carry a concealed pistol. The correct answer is A. Advise the applicant that eligibility is determined by a strict review of South Dakota codified laws, specifically SDCL 23-7-50, and that a simple assault misdemeanor may be a disqualifying offense depending on its classification and the specific statutory language, recommending they consult the official statutes or the Attorney General's office for definitive guidance. Explanation. The assessment process reveals a scenario where an applicant for a South Dakota non-resident permit to carry a concealed pistol has a past misdemeanor conviction for simple assault. This presents a professional challenge because the applicant's eligibility hinges on a nuanced interpretation of South Dakota law regarding disqualifying offenses, specifically whether a simple assault misdemeanor constitutes a crime of violence or a similar disqualifying category under SDCL 23-7-50. The applicant's belief that their offense is minor and unrelated to firearm violence requires careful consideration against the statutory language. The best professional approach involves a thorough review of the specific South Dakota statutes governing eligibility for a concealed pistol permit, particularly SDCL 23-7-50. Which outlines disqualifying offenses. This approach requires consulting the most current version of the South Dakota codified laws and any relevant administrative rules or interpretations issued by the South Dakota Attorney General's office. The applicant should be advised that eligibility is determined solely by the statutory criteria, and a conviction for simple assault, depending on the specific circumstances and how it is classified under South Dakota law, may indeed be a disqualifying offense. The professional's duty is to accurately inform the applicant of the legal requirements and the potential impact of their past conviction based on the plain language of the law, without offering personal opinions or guarantees. An incorrect approach would be to dismiss the applicant's concern based on the assumption that a misdemeanor is always minor and therefore not disqualifying. This fails to acknowledge that South Dakota law, like many jurisdictions, defines specific misdemeanor offenses that can disqualify an applicant, regardless of the applicant's perception of its severity or relevance to firearm use. Another incorrect approach would be to advise the applicant that they are automatically eligible because the conviction was a misdemeanor and not a felony. This overlooks the possibility that certain misdemeanors are explicitly listed as disqualifying under SDCL 23-7-50. Finally, an incorrect approach would be to provide a definitive yes or no answer regarding eligibility without a direct and thorough examination of the relevant South Dakota statutes and how the applicant's specific conviction aligns with those provisions. This constitutes providing legal advice beyond the scope of professional responsibility and risks misinforming the applicant. Professionals should employ a decision-making process that prioritizes adherence to the specific legal framework of South Dakota. This involves 1. Identifying the relevant statute, SDCL 23-7-50. 2. Carefully examining the definitions and categories of disqualifying offenses within that statute. 3. Researching any case law or administrative interpretations that clarify the application of these provisions to specific offenses like simple assault. 4. Communicating the legal requirements and potential implications to the applicant based on this objective research, emphasizing that the final determination rests with the issuing authority. Question 8. The audit findings indicate that a South Dakota non-resident concealed pistol permit application was approved based on the applicant's valid permit from their home state, without a detailed review of whether the applicant met South Dakota's specific firearms training requirements for non-residents. Which of the following represents the most appropriate professional response to this finding? Option A. Conclude that the permit was validly issued due to reciprocity, as South Dakota generally recognizes concealed carry permits from other states. Option B. Advise the applicant that their permit is now under review and request they resubmit proof of training that is specifically tailored to South Dakota's curriculum. Option C. Initiate a review of the applicant's file to verify if the firearms training completed meets the specific standards outlined in South Dakota Codified Law Chapter 23-7, And if not, take appropriate action to revoke the permit. Option D. Recommend an update to the application system to automatically flag all non-resident applications for expedited review based on their out-of-state permit. The correct answer is C. Initiate a review of the applicant's file to verify if the firearms training completed meets the specific standards outlined in South Dakota Codified Law Chapter 23-7, and if not, take appropriate action to revoke the permit. Explanation. The audit findings indicate a potential lapse in diligence regarding the verification of a South Dakota non-resident applicant's eligibility for a concealed pistol permit. This scenario is professionally challenging because it requires a thorough understanding of South Dakota's specific legal requirements for non-resident permits, balancing the applicant's rights with public safety obligations, and ensuring compliance with the established statutory framework. A failure to adhere to these requirements can have significant legal and ethical ramifications. The best professional approach involves meticulously reviewing the applicant's submitted documentation against the explicit criteria outlined in South Dakota Codified Law, SDCL, Chapter 23-7, specifically focusing on the requirements for non-residents. This includes verifying that the applicant is at least 21 years of age, is not disqualified by any grounds listed in SDCL 23-7-10, and has provided proof of completion of a firearms training course that meets the standards set forth in SDCL 23-7-11. The justification for this approach lies in the direct mandate of SDCL 23-7-14, which outlines the process for issuing permits to non-residents and necessitates adherence to the same substantive eligibility criteria as residents, along with specific residency documentation, if applicable. This ensures that only individuals legally permitted to carry a concealed pistol under South Dakota law are issued a permit, upholding the integrity of the permitting process and public safety. An incorrect approach would be to assume that because the applicant possesses a valid concealed carry permit from another state, South Dakota's requirements are automatically met. This fails to acknowledge that South Dakota law, as detailed in SDCL 23-7-14, requires independent verification of eligibility under South Dakota statutes, not merely reciprocity based on another state's issuance. Another incorrect approach is to overlook the firearms training requirement for non-residents, assuming it is waived if the applicant has prior training from their home state. SDCL 23-7-11 clearly defines the acceptable training, and a non-resident must demonstrate compliance with these specific South Dakota standards. Finally, an approach that prioritizes expediency over thoroughness, such as approving the permit based on a cursory review of the application without cross-referencing all statutory requirements, is also professionally unacceptable. This bypasses the due diligence mandated by law and risks issuing a permit to an unqualified individual, thereby failing in the duty to protect public safety and uphold the law. Professionals in this role should employ a systematic decision-making process that begins with a comprehensive understanding of the relevant South Dakota statutes governing concealed pistol permits for both residents and non-residents. This involves consulting the most current versions of SDCL Chapter 23-7 and any accompanying administrative rules. When evaluating an application, a checklist derived directly from these legal requirements should be used to ensure every criterion is addressed. Any ambiguities or missing information should be proactively addressed by requesting clarification or additional documentation from the applicant, rather than making assumptions. This methodical and legally grounded approach ensures that decisions are not only compliant, but also defensible and contribute to the overall safety and security of the state. Question 9. Operational review demonstrates that a resident of Nebraska who holds a valid Nebraska concealed handgun permit plans to travel to South Dakota for an extended visit and wishes to carry their concealed handgun. They have heard that South Dakota recognizes permits from other states, but are unsure of the specific requirements and limitations for non-residents. What is the most prudent course of action for this individual to ensure they are legally carrying a concealed pistol in South Dakota? Option A. Assume that their Nebraska concealed handgun permit is automatically recognized in South Dakota due to reciprocity and proceed with carrying their concealed handgun. Option B. Rely on advice from online forums and discussions with friends who have experience carrying firearms in South Dakota to understand the rules. Option C. Proactively research South Dakota Codified Law SDCL, Chapter 23-7, and consult official South Dakota government resources to determine the specific terms of reciprocity and any requirements for non-residents carrying a concealed pistol. Option D. Focus solely on complying with Nebraska's laws regarding concealed carry, as their permit is issued by their home state. Correct answer is C. Proactively research South Dakota Codified Law SDCL, Chapter 23-7, and consult official South Dakota government resources to determine the specific terms of reciprocity and any requirements for non-residents carrying a concealed pistol. Explanation. This scenario is professionally challenging because it requires an individual to navigate the complexities of interstate recognition of concealed carry permits, specifically concerning South Dakota's reciprocity agreements. The core challenge lies in accurately identifying and applying the correct legal framework for a non-resident seeking to carry a concealed pistol within South Dakota, ensuring compliance with both South Dakota law and the laws of their home state. Misinterpreting these regulations can lead to serious legal consequences, including criminal charges. The best professional approach involves proactively and thoroughly researching South Dakota's specific statutes and administrative rules pertaining to non-resident permits and reciprocity. This includes understanding the conditions under which South Dakota recognizes permits issued by other states and any specific requirements or limitations that apply to non-residents. Consulting official South Dakota government resources, such as the Attorney General's Office or the Department of Public Safety, is paramount. This approach is correct because it directly addresses the legal requirements of the jurisdiction where the individual intends to carry a concealed pistol. South Dakota Codified Law SDCL, Chapter 23-7, specifically sections related to concealed pistol permits and reciprocity, governs this matter. Adhering to these statutes ensures lawful possession and carrying of a concealed pistol, preventing violations of South Dakota law. An incorrect approach would be to assume that a concealed carry permit issued by another state automatically grants the right to carry a concealed pistol in South Dakota without verifying specific reciprocity agreements. This fails to acknowledge that South Dakota law dictates the terms of recognition for non-resident permits. Relying solely on the permit from one's home state without confirming its validity and recognition in South Dakota is a direct violation of SDCL 23-7-7, which outlines the requirements for carrying a concealed pistol and the conditions for reciprocity. Another incorrect approach is to rely on informal advice from friends, online forums, or outdated information. This is professionally unacceptable because it bypasses the authoritative legal sources and can lead to significant misunderstandings of current South Dakota law. Legal requirements are subject to change, and informal sources are not legally binding or reliable. This approach risks violating SDCL 23-7-7 and related statutes due to misinformation. A third incorrect approach is to only consider the laws of the individual's home state. While understanding one's home state laws is important, it is insufficient when carrying a concealed pistol in another jurisdiction. South Dakota law governs the act of carrying a concealed pistol within its borders, regardless of where the permit was issued. This approach ignores the extraterritorial application of South Dakota's laws as established in SDCL 23-7. The professional decision-making process for similar situations should begin with identifying the relevant jurisdiction. Next, the professional must identify the specific laws and regulations governing the activity in question within each relevant jurisdiction. This involves consulting official government websites, statutes, and administrative codes. If ambiguity exists, seeking clarification from the relevant regulatory body or legal counsel is advisable. Finally, the professional must ensure all actions taken are in strict compliance with the identified legal requirements. Question 10. The evaluation methodology shows that a South Dakota resident is applying for a non-resident permit to carry a concealed pistol in the state of Wyoming. The Wyoming application instructions state a base application fee of $100, a fingerprinting fee of $30, and a background check fee of $20. If the applicant also needs to pay a $5 administrative fee for processing the out-of-state application, what is the total amount the applicant must submit with their application? Option A, $150, Option B, $155, Option C, $125, Option D, $130. Correct answer is B, $155. Explanation. This scenario presents a professional challenge for a South Dakota resident applying for a non-resident permit to carry a concealed pistol in a neighboring state. The core difficulty lies in accurately calculating the required fees, which are subject to specific state regulations and can vary based on processing times and potential administrative costs. Miscalculating these fees can lead to application rejection, delays, and potential misunderstandings with the issuing authority, impacting the applicant's ability to legally carry a concealed pistol. Careful judgment is required to ensure all applicable fees are identified and correctly computed according to the specific laws of the state where the permit is being sought. The best professional approach involves meticulously reviewing the South Dakota Attorney General's website or the official application instructions for the non-resident permit. This would involve identifying the base application fee, any fingerprinting fees, and any additional administrative or processing fees that may be mandated by the issuing state statutes. For instance, if the application fee is $100, the fingerprinting fee is $25, and a background check fee is $15, the total would be calculated as follows. Total fee equals base application fee plus fingerprinting fee plus background check fee. In this example, the total would be $100 plus $25 plus $15 equals $140. This approach is correct because it directly adheres to the regulatory requirements for permit applications, ensuring the applicant submits the precise amount of money required by law, thereby maximizing the likelihood of a successful and timely application. An incorrect approach would be to estimate the fee based on past experience or information from a different state. This is professionally unacceptable because South Dakota's reciprocity agreements and the fee structures of other states are governed by their own specific legislative enactments. Relying on outdated or irrelevant information can lead to underpayment, resulting in the application being returned or denied, or overpayment, which, while less problematic, is still an inefficient use of the applicant's funds and can indicate a lack of diligence. Another incorrect approach would be to only pay the base application fee and disregard any mention of additional processing or background check fees. This is a significant regulatory failure, as these additional fees are often statutory requirements for processing the application and conducting necessary background investigations. Failure to remit these mandated fees constitutes noncompliance with the application requirements and will almost certainly lead to the application being rejected. A third incorrect approach would be to assume that the fee structure is uniform across all states that offer non-resident permits. This assumption is flawed because each state has the sovereign right to set its own fees for issuing permits, reflecting its administrative costs and legislative decisions. Applying a generic fee without verifying the specific requirements of the target state is a direct violation of the principle of adhering to the laws of the jurisdiction where the permit is being sought. The professional decision-making process for such situations should involve a systematic verification of all requirements. This includes consulting official government sources for the most current information, cross-referencing application instructions with relevant statutes if necessary, and ensuring all financial obligations are met precisely as stipulated. Professionals should prioritize accuracy and compliance over assumptions or estimations to ensure the integrity of the application process and the applicant's legal standing. Question 11. System analysis indicates that a South Dakota resident who has obtained a non-resident permit to carry a concealed pistol plans to travel to Wyoming for an extended stay. The resident wishes to carry their concealed pistol while in Wyoming and needs to understand their legal standing. Which of the following actions represents the most prudent and legally compliant approach for the South Dakota resident? Option A. Assume that a valid permit issued by South Dakota is automatically recognized in Wyoming, as most states have reciprocal agreements for concealed carry. Option B. Rely on advice from online firearm forums and discussions with fellow gun owners to understand Wyoming's rules regarding out-of-state permits. Option C. Carry the concealed pistol in Wyoming, believing that their South Dakota permit is sufficient, and only address any legal issues if they arise. Option D. Proactively research and verify the specific reciprocity laws between South Dakota and Wyoming to determine if South Dakota's non-resident permit is recognized in Wyoming and under what conditions. The correct answer is D. Proactively research and verify the specific reciprocity laws between South Dakota and Wyoming to determine if South Dakota's non-resident permit is recognized in Wyoming and under what conditions. Explanation. Scenario analysis. This scenario presents a professional challenge for a South Dakota resident seeking to carry a concealed pistol while temporarily residing in Wyoming. The core difficulty lies in navigating the reciprocity agreements between states regarding concealed carry permits. A failure to understand these agreements can lead to unintentional violations of firearm laws, potentially resulting in severe legal consequences. Careful judgment is required to ensure compliance with both South Dakota's issuance requirements and Wyoming's recognition of out-of-state permits. Correct approach analysis. The best professional practice involves proactively researching and understanding the specific reciprocity laws between South Dakota and Wyoming. This means contacting the relevant law enforcement agencies or official government websites in both states to ascertain whether South Dakota's non-resident permit to carry a concealed pistol is recognized in Wyoming and under what conditions. This approach is correct because it prioritizes legal compliance and informed decision-making, directly addressing the jurisdictional complexities of carrying a firearm across state lines. It aligns with the ethical obligation to act within the bounds of the law and to avoid actions that could jeopardize personal safety or legal standing. Incorrect approach is analysis. One incorrect approach is to assume that a valid permit issued by one state is automatically recognized by all other states. This assumption is dangerous and legally unsound, as firearm reciprocity is governed by specific agreements and state statutes, not by a universal principle. This failure to verify reciprocity can lead to carrying a concealed weapon in Wyoming without proper authorization, violating Wyoming's firearm laws. Another incorrect approach is to rely on informal advice from friends or online forums regarding reciprocity. While well-intentioned, such sources may not be up-to-date or accurate, and they do not carry legal weight. Basing a decision on such information constitutes a failure to conduct due diligence and can result in unknowingly violating the law, leading to potential arrest and prosecution. A third incorrect approach is to only consider South Dakota's permit requirements and disregard the laws of the state where the individual intends to carry. This demonstrates a lack of understanding of jurisdictional authority. When carrying a firearm in Wyoming, the laws of Wyoming are paramount, and South Dakota's permit is only relevant if Wyoming recognizes it through reciprocity. Ignoring Wyoming's laws is a direct violation of its sovereign authority to regulate firearms within its borders. Professional reasoning. Professionals facing such cross-jurisdictional issues should adopt a systematic approach. First, identify the relevant jurisdictions involved. Second, determine the legal requirements for carrying a concealed weapon in each jurisdiction. Third, research any existing reciprocity agreements or recognition clauses between these jurisdictions. Fourth, consult official sources of information such as state statutes, legislative websites, or law enforcement agencies for definitive guidance. Finally, err on the side of caution and seek clarification when in doubt, rather than proceeding with an action that could have legal ramifications. Question 12. Implementation of South Dakota's concealed carry regulations for non-residents presents a common advisory challenge for financial professionals. A client, who is a resident of a neighboring state and holds a valid concealed carry permit from their home state, is planning an extended stay in South Dakota and inquires about the validity of their permit and the process for obtaining a South Dakota non-resident permit. What is the most appropriate and legally compliant course of action for the financial advisor? Option A. Inform the client that their current out-of-state concealed carry permit is likely valid in South Dakota due to reciprocity, and they likely do not need to apply for a separate permit. Option B. Offer to help the client complete the South Dakota non-resident permit application form using the information they provide to ensure it is submitted correctly. Option C. Provide the client with a direct link to a third-party website that claims to offer expedited services for obtaining South Dakota concealed carry permits. Option D. Advise the client to consult the official South Dakota Attorney General's office website or relevant state statutes for precise details on non-resident permit requirements, reciprocity, and the application process, while clarifying that the advisor cannot provide legal advice or assist with the application itself. The correct answer is D. Advise the client to consult the official South Dakota Attorney General's office website or relevant state statutes for precise details on non-resident permit requirements, reciprocity, and the application process, while clarifying that the advisor cannot provide legal advice or assist with the application itself. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of South Dakota's concealed carry laws, specifically concerning non-resident permits and the ethical obligation to uphold these regulations. A financial advisor must balance client service with strict adherence to legal requirements, ensuring no misrepresentation or facilitation of illegal activity occurs. The core challenge lies in accurately advising a client on the process and requirements without overstepping professional boundaries or providing advice that could lead to legal complications for the client. Correct approach analysis. The best professional practice involves clearly and accurately informing the client about the South Dakota requirements for obtaining a non-resident permit to carry a concealed pistol. This includes directing them to the official South Dakota Attorney General's office website or relevant state statutes for the most up-to-date and authoritative information on eligibility, application procedures, required documentation, and any associated fees. This approach is correct because it respects the client's autonomy while ensuring they receive accurate, legally sound guidance directly from the source, thereby avoiding the advisor providing potentially outdated or incomplete information that could have legal ramifications. It upholds the advisor's duty to act with due diligence and to avoid engaging in activities that require specific licensure or authorization they do not possess. Incorrect approaches analysis. Providing a direct link to a third-party website that offers expedited or guaranteed permit services is an incorrect approach. This is because such sites may not be officially sanctioned, could charge exorbitant fees, or might not accurately reflect South Dakota's legal requirements, potentially leading the client to believe they are compliant when they are not. Furthermore, it risks associating the advisor with potentially fraudulent or misleading services. Advising the client that their current out-of-state permit is automatically valid in South Dakota without verifying reciprocity agreements is also incorrect. South Dakota law dictates specific reciprocity rules, and assuming validity without confirmation could lead to the client unknowingly violating South Dakota's concealed carry laws. Finally, offering to assist the client with filling out the application form, even with the best intentions, is an incorrect approach. This could be construed as providing legal advice or acting as an agent for the application process, which may require specific licensing or authorization that a financial advisor does not possess, and could lead to liability if errors are made. Professional reasoning. Professionals should always prioritize accuracy and legal compliance. When advising clients on matters that intersect with legal requirements, such as obtaining permits or licenses, the decision-making process should involve 1. Identifying the specific legal jurisdiction involved, South Dakota in this case. 2. Determining the scope of one's own professional expertise and licensing. Financial advisors are not typically licensed to provide legal advice or assist directly with permit applications. 3. Directing clients to official government sources for definitive information and procedures. 4. Avoiding any action that could be interpreted as providing legal advice or acting as an agent for a process requiring specific authorization. 5. Verifying any information provided, especially regarding reciprocity or validity of existing permits, through official channels. Question 13. To address the challenge of a resident of Iowa who holds a valid Iowa permit to carry a concealed pistol, planning a hunting trip to South Dakota, what is the most prudent course of action to ensure legal compliance regarding carrying their firearm? Option A. Contact the South Dakota Attorney General's office or the relevant state law enforcement agency to confirm if South Dakota recognizes Iowa's permit to carry a concealed pistol. Option B. Assume that because Iowa has a concealed carry permit, it will be automatically recognized in South Dakota due to reciprocity agreements between states. Option C. Proceed with carrying their concealed pistol in South Dakota, believing that as a visitor with a valid permit from their home state, they are unlikely to encounter legal issues. Option D. Rely on advice from an online firearms forum, where other users discuss their experiences carrying in South Dakota with out-of-state permits. The correct answer is A. Contact the South Dakota Attorney General's office or the relevant state law enforcement agency to confirm if South Dakota recognizes Iowa's permit to carry a concealed pistol. Explanation. The scenario presents a professional challenge because it requires an individual to navigate the complexities of South Dakota's concealed carry laws as a non-resident, specifically concerning the validity of their out-of-state permit. Misinterpreting or failing to adhere to these regulations can lead to serious legal consequences, including potential criminal charges and the denial of future permits. Careful judgment is required to ensure compliance with South Dakota's specific statutory requirement for recognizing permits from other states. The best professional approach involves proactively verifying the reciprocity status of the individual's home state permit with South Dakota. This means consulting official South Dakota government resources, such as the Attorney General's office or the relevant state law enforcement agency, to determine if South Dakota recognizes concealed carry permits issued by the individual's home state. This approach is correct because South Dakota law, specifically SDCL 23-7-57, outlines the conditions under which a non-resident permit to carry a concealed pistol is recognized. By directly confirming reciprocity, the individual ensures they are acting in accordance with the explicit legal framework established by South Dakota for non-resident permit holders. This proactive verification demonstrates a commitment to legal compliance and responsible firearm ownership. An incorrect approach would be to assume that because the individual possesses a valid concealed carry permit in their home state, it is automatically recognized in South Dakota. This assumption is flawed because South Dakota law does not grant automatic recognition to all out-of-state permits. Relying on such an assumption could lead to carrying a concealed pistol in South Dakota without legal authorization, violating SDCL 23-7-57 and potentially facing penalties. Another incorrect approach would be to rely solely on informal advice from friends or online forums regarding permit recognition. While these sources may sometimes offer accurate information, they do not constitute official legal guidance. South Dakota law requires adherence to its specific statutory provisions, and informal advice does not provide the necessary legal certainty or protection. Acting on such advice could result in unknowingly violating the law. Finally, an incorrect approach would be to proceed with carrying a concealed pistol in South Dakota without any attempt to verify permit recognition, believing that enforcement is unlikely or that their home state permit is universally accepted. This demonstrates a disregard for the legal requirements of South Dakota and a failure to exercise due diligence. Such an attitude is professionally unacceptable and carries significant legal risks. The professional decision-making process for similar situations should involve a commitment to understanding and adhering to the specific laws of the jurisdiction in which one intends to carry a concealed weapon. This includes identifying the relevant statutes, consulting official government sources for clarification, and making decisions based on verified legal information rather than assumptions or informal advice. Question 14. The review process indicates that a South Dakota non-resident concealed pistol permit application has been submitted by an individual who holds a valid concealed carry permit from their home state of Nebraska. The applicant's Nebraska permit was issued after they met Nebraska's statutory requirements, which include a background check and a firearms training course. However, South Dakota law requires non-resident permit holders to meet certain eligibility criteria beyond just holding a permit from their home state. Considering the nuances of South Dakota's reciprocity laws and its independent requirements for non-resident permittees, which of the following actions represents the most appropriate and legally compliant response? Option A. Deny the South Dakota non-resident permit because Nebraska's firearms training requirements may differ from those mandated by South Dakota for its own residents, creating a potential disparity. Option B. Verify the validity of the Nebraska permit and confirm the applicant meets South Dakota's age and residency requirements, and that they have no disqualifying criminal history or mental health adjudications as defined by South Dakota law before approving the application. Option C. Forward the application to the Nebraska State Sheriff's Office for their assessment of the applicant's suitability under South Dakota law, as they are the issuing authority for the applicant's home state permit. Option D. Approve the South Dakota non-resident permit solely based on the applicant possessing a valid concealed carry permit from Nebraska, assuming reciprocity fully covers all eligibility requirements. The correct answer is B. Verify the validity of the Nebraska permit and confirm the applicant meets South Dakota's age and residency requirements, and that they have no disqualifying criminal history or mental health adjudications as defined by South Dakota law before approving the application. Explanation: the review process indicates a potential issue with a South Dakota non-resident applicant's concealed pistol permit application. The challenge here lies in accurately interpreting and applying South Dakota's reciprocity laws and the specific requirements for non-resident applicants, particularly when the applicant's home state has different or less stringent regulations. Misinterpreting these nuances can lead to either the improper denial of a permit or the issuance of a permit to an individual who may not meet all the necessary criteria under South Dakota law. The best approach involves a thorough examination of the applicant's out-of-state permit and the laws of their home state in conjunction with South Dakota's specific requirements for non-resident permits. This includes verifying that the applicant's home state permit is valid and that the applicant meets all the eligibility criteria outlined in South Dakota Codified Law, SDCL, Chapter 23-7, specifically regarding age, residency, and any disqualifying factors. Furthermore, it requires understanding the provisions for reciprocity as outlined in SDCL 23-7-10, which governs the recognition of permits issued by other states. This meticulous cross-referencing ensures compliance with both the spirit and letter of South Dakota's concealed carry laws for non-residents. An incorrect approach would be to solely rely on the validity of the applicant's out-of-state permit without verifying if the applicant meets South Dakota's independent eligibility criteria. This fails to acknowledge that South Dakota's reciprocity provisions do not automatically waive its own fundamental requirements for permit holders, such as those related to disqualifying criminal convictions or mental health adjudications, which might not be as stringently assessed in the applicant's home state. Another flawed approach is to assume that if the applicant's home state issues permits, South Dakota will automatically recognize it for non-resident purposes, disregarding the specific statutory language in SDCL 23-7-10 that outlines the conditions for such recognition. Finally, an approach that prioritizes expediency over accuracy, such as approving the permit based on a cursory review of the out-of-state documentation, risks overlooking critical disqualifying factors and undermines the public safety objectives of the permitting process. Professionals should employ a systematic decision-making process that begins with identifying the specific jurisdiction's laws governing the matter, South Dakota in this case. This involves consulting the relevant statutes, SDCL Chapter 23-7, and related sections on reciprocity, and any administrative rules or guidance issued by the permitting authority. The next step is to gather all necessary documentation from the applicant and their home state. The core of the process is a comparative analysis, assessing the applicant's qualifications against South Dakota's requirements and verifying the validity and basis of their out-of-state permit in light of South Dakota's reciprocity rules. Any discrepancies or ambiguities should be resolved through further research or consultation with legal counsel or senior officials within the permitting agency before a final decision is rendered. Question 15. Examination of the data shows that an individual is applying for a South Dakota non-resident permit to carry a concealed pistol and has completed the application form, but realizes they have misplaced the certificate proving their firearm proficiency training, which is a stated requirement for the permit. The applicant is eager to submit the application promptly. Which of the following actions best aligns with South Dakota's regulatory framework for concealed pistol permits? Option A. Submit the application with the missing certificate and a note indicating that the training was completed, assuming the authorities will verify it through other means. Option B. Delay submitting the application until the original firearm proficiency training certificate can be located and included with the application. Option C. Submit the application without mentioning the missing certificate, hoping that the omission will not be noticed during the review process. Option D. Submit the application with a detailed explanation of the missing certificate and a sworn statement that the training was completed, promising to provide the certificate as soon as it is located. The correct answer is D. Submit the application with a detailed explanation of the missing certificate and a sworn statement that the training was completed, promising to provide the certificate as soon as it is located. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an individual seeking a South Dakota non-resident permit to carry a concealed pistol to navigate the specific application requirements and understand the implications of providing incomplete or misleading information. The challenge lies in ensuring full compliance with South Dakota law, which prioritizes accuracy and completeness in all submitted documentation to uphold public safety and the integrity of the permitting process. Correct approach analysis. The best professional practice involves meticulously reviewing the South Dakota application requirements for a non-resident permit to carry a concealed pistol and ensuring all requested information is provided accurately and completely. This approach is correct because South Dakota Codified Law, SDCL, Chapter 23-7, specifically SDCL 23-7-50 through 23-7-63, governs the issuance of concealed pistol permits. These statutes mandate that applicants provide truthful and complete information. Failure to do so can result in denial of the permit and potential legal consequences. Adhering strictly to the stated requirements demonstrates a commitment to lawful conduct and respect for the permitting authority's need for accurate data. Incorrect approach is analysis. Submitting an application with a known omission of a required document, such as proof of firearm proficiency training, that is explicitly listed as a prerequisite in SDCL 23-7-53, is a regulatory failure. This directly contravenes the statutory requirement for demonstrating competency and can lead to the denial of the permit. Furthermore, it suggests a lack of diligence and an attempt to circumvent established safety protocols. Providing a sworn statement that all requirements have been met when a key component is missing is also a misrepresentation, which undermines the integrity of the application process and violates the spirit and letter of the law. This could be construed as an attempt to deceive the permitting authority, leading to potential penalties beyond permit denial. Professional reasoning. Professionals in this situation should adopt a systematic approach to application processes. This involves 1. Thoroughly understanding all stated requirements for the specific permit being sought, referencing the relevant statutes, in this case, SDCL Chapter 23-7. 2. Gathering all necessary supporting documentation and verifying its completeness and accuracy. 3. If any requirement is unclear or if a document is difficult to obtain, proactively seeking clarification from the issuing authority or legal counsel rather than making assumptions or omissions. 4. Submitting the application only when all requirements are fully satisfied, ensuring all information is truthful and accurate. Question 16. Upon reviewing the requirements for carrying a concealed pistol in South Dakota, a resident of Iowa who holds a valid concealed carry permit from their home state is seeking to understand the process for legally carrying a concealed pistol within South Dakota. What is the most appropriate course of action for this individual to ensure compliance with South Dakota law? Option A. Assume that their valid Iowa concealed carry permit grants them the right to carry a concealed pistol in South Dakota due to general reciprocity principles among states. Option B. Thoroughly research and comply with South Dakota's specific statutory requirements for obtaining a non-resident permit to carry a concealed pistol, including any application process, required documentation, and potential reciprocity considerations. Option C. Focus solely on general federal firearm regulations, believing these will cover all aspects of concealed carry in South Dakota. Option D. Rely on information gathered from online firearm enthusiast forums to determine the necessary steps for carrying a concealed pistol in South Dakota. Correct answer is B. Thoroughly research and comply with South Dakota's specific statutory requirements for obtaining a non-resident permit to carry a concealed pistol, including any application process, required documentation, and potential reciprocity considerations. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an individual to navigate the specific legal requirements for obtaining a non-resident permit to carry a concealed pistol in South Dakota, while also considering the implications of their existing permit from another state. Misunderstanding or misapplying these requirements can lead to legal complications, denial of the permit, or even unintentional violations of South Dakota law. Careful judgment is required to ensure full compliance with the designated jurisdiction's regulations. Correct approach analysis. The best professional approach involves thoroughly researching and adhering to South Dakota's specific statutory requirements for non-resident concealed carry permits. This includes understanding the application process, any reciprocity agreements South Dakota may have with the applicant's home state, and any specific training or documentation mandated by South Dakota law for non-residents. This approach is correct because it prioritizes direct compliance with the laws of the jurisdiction where the permit is being sought, ensuring all legal prerequisites are met. South Dakota Codified Law Chapter 23-7, specifically sections related to permits to carry dangerous weapons, outlines these requirements. Incorrect approaches analysis. One incorrect approach is to assume that a valid concealed carry permit from another state automatically grants reciprocal rights in South Dakota without verifying specific reciprocity agreements or application procedures. This fails to acknowledge that South Dakota has its own distinct legal framework for issuing permits to non-residents, and simply relying on an out-of-state permit without due diligence can lead to a violation if South Dakota law requires a separate application or specific conditions to be met. Another incorrect approach is to only consult general firearm laws without focusing on the specific provisions for non-resident permits. While general firearm laws are relevant, they may not address the unique application process, documentation, or eligibility criteria that South Dakota imposes on individuals who are not residents of the state. This oversight can result in an incomplete or improperly submitted application. A further incorrect approach is to rely solely on information from online forums or unofficial sources regarding South Dakota's concealed carry laws. While these sources may offer some guidance, they are not authoritative and can contain outdated or inaccurate information. Legal requirements are precise, and relying on unofficial advice can lead to significant errors in understanding and fulfilling the application process. Professional reasoning. Professionals facing this situation should adopt a systematic approach. First, identify the specific jurisdiction's laws governing concealed carry permits for non-residents. Second, consult official government sources, such as the South Dakota Department of Public Safety or the relevant legislative statutes, for accurate and up-to-date information. Third, understand the application process, including required documentation, fees, and any training prerequisites. Fourth, verify any reciprocity agreements between the applicant's home state and South Dakota. Finally, ensure all application materials are complete and submitted according to the specified procedures. Question 17. When evaluating an individual's eligibility for a non-resident permit to carry a concealed pistol in South Dakota, what is the most critical step a professional must undertake to ensure compliance with state law? Option A. Assuming that a valid concealed carry permit from any other U.S. state is sufficient for carrying concealed in South Dakota due to national firearm rights. Option B. Relying on general knowledge of concealed carry laws across various states to advise the applicant on their rights in South Dakota. Option C. Advising the applicant to carry their firearm openly, as this is generally permitted and avoids the complexities of concealed carry permits for non-residents. Option D. Verifying the applicant's current concealed carry permit from their home state and confirming South Dakota's reciprocity agreement with that state, along with ensuring the applicant meets all South Dakota statutory eligibility requirements for non-residents. The correct answer is D. Verifying the applicant's current concealed carry permit from their home state and confirming South Dakota's reciprocity agreement with that state, along with ensuring the applicant meets all South Dakota statutory eligibility requirements for non-residents. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of South Dakota's concealed carry laws, specifically concerning non-resident permits, and the potential for misinterpreting or misapplying these regulations. A professional must navigate the specific requirements for obtaining and maintaining such a permit, recognizing that ignorance of the law is not a defense and that adherence is paramount for legal firearm possession. The challenge lies in distinguishing between general firearm rights and the specific, regulated process for carrying a concealed weapon as a non-resident. Correct approach analysis. The best professional approach involves a thorough review of the South Dakota Codified Laws, SDCL, pertaining to concealed carry permits for non-residents. This includes understanding the application process, eligibility criteria, reciprocity agreements with other states, and the specific prohibitions outlined in SDCL 23-7-51 through 23-7-61. Professional must confirm that the individual meets all statutory requirements, such as age, residency in a reciprocating state, and absence of disqualifying factors, and has successfully completed the required training. This approach is correct because it directly addresses the legal framework governing non-resident concealed carry permits in South Dakota, ensuring compliance with all applicable statutes and regulations. Incorrect approach is analysis. One incorrect approach is to assume that a valid concealed carry permit from another state automatically grants the right to carry concealed in South Dakota. This fails to acknowledge that South Dakota has specific statutes and potentially different requirements for non-residents, and that reciprocity is not universal or unconditional. It overlooks the need to verify if South Dakota has a formal reciprocity agreement with the applicant's home state, and if all conditions of that agreement are met. Another incorrect approach is to rely solely on general information about firearm rights without consulting the specific South Dakota statutes. This can lead to a misunderstanding of the nuances of concealed carry laws, such as prohibited locations or specific permit requirements that may differ from other jurisdictions. It ignores the detailed legal framework established by the South Dakota legislature. A third incorrect approach is to provide advice based on anecdotal evidence or common practices in other states. This is professionally unacceptable, as it disregards the precise legal requirements of South Dakota. Legal advice must be grounded in the specific statutes and regulations of the jurisdiction in question, not on generalized assumptions or hearsay. Professional reasoning. Professionals dealing with jurisdiction-specific firearm regulations must adopt a systematic approach. First, identify the specific jurisdiction and the relevant laws. Second, consult the official statutes and administrative rules of that jurisdiction. Third, verify any reciprocity agreements or specific provisions for non-residents. Fourth, ensure all eligibility criteria and procedural requirements are met. Finally, document all advice and the basis for it, referencing the specific legal provisions. This methodical process ensures accuracy and compliance, mitigating legal and ethical risks. Question 18. The analysis reveals that a resident of Wyoming, who legally possesses a concealed carry permit issued by their home state, wishes to obtain a non-resident permit to carry a concealed pistol in South Dakota. Based on South Dakota codified law, what is the most appropriate course of action for the South Dakota authorities to take when processing this application? Option A. Verify the applicant's Wyoming permit. Confirm they meet South Dakota's age and disqualifying criteria, as per SDCL 23-7-52 and SDCL 23-7-53. And ensure their home state has a reciprocal agreement or that South Dakota law permits non-resident permits under SDCL 23-7-51. Then process the application according to SDCL 23-7-54. Option B. Issue a non-resident permit automatically, assuming that a valid permit from another state is sufficient for concealed carry in South Dakota. Option C. Process the application based on the laws of Wyoming, as that is the state where the applicant currently holds a concealed carry permit. Option D. Deny the application solely because the applicant is not a resident of South Dakota, without further review of their qualifications or reciprocity. Correct answer is A. Verify the applicant's Wyoming permit. Confirm they meet South Dakota's age and disqualifying criteria as per SDCL 23-7-52 and SDCL 23-7-53, and ensure their home state has a reciprocal agreement or that South Dakota law permits non-resident permits under SDCL 23-7-51. Then process the application according to SDCL 23-7-54. Explanation. The analysis reveals a scenario where an individual seeking to carry a concealed pistol in South Dakota must navigate the specific requirements for obtaining a non-resident permit. The professional challenge lies in accurately interpreting and applying South Dakota's statutory provisions concerning reciprocity and the qualifications for non-residents, ensuring compliance without overstepping or misinterpreting the law. This requires a meticulous review of the relevant statutes to avoid potential legal repercussions for the applicant or the issuing authority. The best professional approach involves a thorough examination of South Dakota Codified Law, SDCL, Chapter 23-7, specifically focusing on the provisions related to permits to carry concealed weapons for non-residents. This includes verifying that the applicant meets the age, residency in their home state, and disqualifying criteria outlined in SDCL 23-7-52 and SDCL 23-7-53. Crucially, It requires confirming that the applicant's home state has a reciprocal agreement with South Dakota for the recognition of concealed carry permits, or that South Dakota law permits non-resident permits under specific conditions as detailed in SDCL 23-7-51. The application must be processed according to the procedures set forth in SDCL 23-7-54, ensuring all required documentation and background checks are completed. This approach is correct because it directly adheres to the statutory framework established by South Dakota law for non-resident permits, prioritizing legal compliance and the safety of the public. An incorrect approach would be to assume that a valid concealed carry permit from another state automatically grants the right to carry concealed in South Dakota without verifying specific reciprocity agreements or non-resident permit eligibility under South Dakota law. This fails to acknowledge SDCL 23-7-51, which outlines the conditions under which a non-resident may be issued a permit, and SDCL 23-7-52 and SDCL 23-7-53, which detail the qualifications and disqualifications. Another incorrect approach would be to rely solely on general knowledge of concealed carry laws without consulting the specific South Dakota statutes, potentially leading to the issuance of a permit to an unqualified individual or the denial of a permit to a qualified one. This disregards the explicit legal requirements of the jurisdiction. A third incorrect approach would be to process the application based on the applicant's home state's laws rather than South Dakota's, which is a fundamental misapplication of jurisdictional authority and violates the principle that permits are issued under the laws of the issuing state. Professionals should employ a decision-making process that begins with identifying the specific jurisdictions governing statutes. This involves locating and meticulously reviewing the relevant sections of the South Dakota codified law pertaining to concealed carry permits for non-residents. The next step is to compare the applicant's qualifications and circumstances against each statutory requirement, ensuring no element is overlooked. Documentation must be verified for accuracy and completeness. If any ambiguity arises, consulting official legal interpretations or seeking guidance from legal counsel specializing in firearms law within South Dakota is paramount. This systematic, statute-driven approach ensures compliance and upholds the integrity of the permitting process. Question 19. Comparative studies suggest that individuals seeking to carry a concealed pistol in South Dakota under a permit issued by another state often face challenges in understanding the scope of their authorization. Considering the specific statutory framework of South Dakota, what is the most prudent course of action for a resident of Montana who holds a valid Montana concealed carry permit and wishes to carry a concealed pistol while temporarily visiting South Dakota? Option A. Rely on information obtained from online firearms enthusiast forums and discussions with friends who have experience carrying firearms in different states to determine the legality of carrying a concealed pistol in South Dakota. Option B. Assume that the Montana concealed carry permit is automatically recognized in South Dakota due to reciprocity, and proceed to carry a concealed pistol without further investigation. Option C. Carry the concealed pistol openly, believing that this method of carrying is less regulated and therefore permissible without needing to verify specific non-resident permit requirements. Option D. Proactively research South Dakota's laws and any reciprocity agreements with Montana to confirm the validity and conditions of carrying a concealed pistol in South Dakota with a Montana permit, and if necessary, apply for a South Dakota non-resident permit to carry a concealed pistol. The correct answer is D. Proactively research South Dakota's laws and any reciprocity agreements with Montana to confirm the validity and conditions of carrying a concealed pistol in South Dakota with a Montana permit, and if necessary, apply for a South Dakota non-resident permit to carry a concealed pistol. Explanation. This scenario is professionally challenging because it requires an individual seeking a South Dakota non-resident permit to carry a concealed pistol to navigate the nuances of reciprocity agreements and understand the limitations of their home state's permit when operating in South Dakota. The core of the challenge lies in accurately interpreting and applying South Dakota's specific statutory requirements for non-residents, which may differ significantly from their state of residence. A failure to do so could result in legal consequences, including criminal charges for carrying a concealed pistol without proper authorization. Careful judgment is required to ensure compliance with all applicable laws. The best professional approach involves proactively researching and understanding South Dakota's specific requirements for non-resident permit holders, including any reciprocity agreements that may be in place with their state of residence. This includes verifying if their home state's permit is recognized, and if any additional steps or documentation are necessary to legally carry a concealed pistol in South Dakota. This approach is correct because it prioritizes adherence to South Dakota law, as outlined in SDCL Chapter 23-7, specifically focusing on the provisions related to permits to carry concealed weapons and the recognition of permits issued by other states. By consulting official South Dakota government resources or legal counsel specializing in firearms law, the individual ensures they are acting within the bounds of the law, thereby avoiding potential legal entanglements. An incorrect approach would be to assume that a valid permit from their state of residence automatically grants them the right to carry a concealed pistol in South Dakota without further verification. This is a regulatory failure because South Dakota law dictates the conditions under which non-resident permits are recognized, and this recognition is not always automatic or universal. Relying solely on one's home state permit without confirming South Dakota's specific acceptance of it is a direct violation of the principle of knowing and abiding by the laws of the jurisdiction in which one is present. Another incorrect approach would be to rely on informal advice from friends or online forums regarding firearms laws. This is an ethical and regulatory failure because such sources are not authoritative and can provide inaccurate or outdated information. Firearms laws are complex and subject to change, and relying on unofficial advice can lead to serious legal repercussions, undermining the professional responsibility to act with due diligence and accuracy. The professional reasoning process for individuals in this situation should involve a multi-step approach. First, identify the specific jurisdiction, South Dakota, and the relevant legal framework, SDCL Chapter 23-7. Second, determine the individual's status, non-resident, and the type of permit sought, concealed pistol. Third, research South Dakota's laws regarding non-resident permits and reciprocity agreements with the individual's state of residence. This research should be conducted through official government websites, legislative statutes, or by consulting with a qualified legal professional. Fourth, if there is any ambiguity, or if the home state permit is not explicitly recognized, explore the process for obtaining a South Dakota non-resident permit to carry a concealed pistol. Finally, always err on the side of caution and ensure full compliance with all applicable laws before carrying a concealed pistol in any jurisdiction. Question 20. The investigation demonstrates that a resident of Nebraska, who currently holds a valid concealed handgun permit issued by Nebraska, has recently relocated to Sioux Falls, South Dakota. This individual wishes to obtain a South Dakota non-resident permit to carry a concealed pistol, based on South Dakota Codified Law 23-7-58, which outlines the fees associated with such permits. And assuming no other relevant statutory exceptions apply, what is the precise cost the applicant must incur to obtain a South Dakota non-resident permit to carry a concealed pistol? Option A, $0, as their Nebraska permit is recognized through reciprocity. Option B, an estimated fee based on average permit costs across neighboring states. Option C, $100. Option D, $100 plus the fee for their Nebraska permit. The correct answer is C, $100. Explanation. This scenario presents a professional challenge because it requires a precise understanding of South Dakota's reciprocity agreements and the financial implications of obtaining a non-resident permit to carry a concealed pistol. The applicant's situation, involving a recent move and a desire to carry legally in South Dakota while maintaining their home state permit, necessitates careful calculation to determine the most cost-effective and legally compliant path. The core of the challenge lies in accurately applying the relevant South Dakota statutes and administrative rules concerning non-resident permits and reciprocity fees. The best approach involves a direct calculation based on the South Dakota Codified Law, SDCL, 23-7-58, which outlines the fees for non-resident permits. This statute specifies a fee of $100 for a non-resident permit. Additionally, South Dakota has reciprocity agreements with other states, meaning a permit from a recognized reciprocating state is generally honored. However, the The question specifically asks about obtaining a South Dakota non-resident permit. Therefore, the applicant must pay the statutory fee for the non-resident permit. The calculation is straightforward. The cost of the non-resident permit is $100. An incorrect approach would be to assume that because the applicant holds a valid permit from another state, they are automatically exempt from paying any fees to obtain a South Dakota non-resident permit. This ignores the specific provisions of SDCL 23-7-58, which mandates a fee for non-residents applying for a South Dakota permit, regardless of whether they hold a permit from another state. While reciprocity allows for recognition of permits, it does not waive the application fee for obtaining a South Dakota permit if that is the desired outcome. Another incorrect approach would be to simply add the fee of a resident permit to the fee of their home state permit. South Dakota codified law does not support such a combined fee structure for non-residents seeking a non-resident permit. The fees are distinct and governed by specific statutes for resident and non-resident applications. A further incorrect approach would be to estimate the cost based on general knowledge of permit fees in other states. This is a critical failure as it disregards the specific statutory requirements of South Dakota. Each state sets its own fees, and relying on assumptions or information from other jurisdictions can lead to significant financial and legal errors. The professional decision-making process for such situations should involve 1. Identifying the specific jurisdiction's laws and regulations governing the permit in question, South Dakota codified law. 2. Determining the applicant's status, non-resident. 3. Locating the relevant statutory provisions for non-resident permits and associated fees. 4. Performing the exact calculation as prescribed by the law. 5. Verifying any reciprocity agreements, but understanding that these do not necessarily waive application fees for obtaining a permit in the new jurisdiction, if that is the applicant's goal.